Conversion of a conventional bank to an Islamic bank. The necessary measures for conversion. 1. The bank will set up all necessary procedures, create the required tools, explore alternatives to non-permissible financial practices, and train and promote the personnel required for proper implementation of the procedures of conversion. 2. The appropriate administrative arrangements must be in place, including changing the bank's operating license, and amending the bank's memorandum and articles of association through the required procedures so that they include objectives and operational measures that are appropriate to Islamic banking. The memorandum and articles of association must be cleansed from anything that contradicts the nature of Islamic banking. 3. Restructuring the organizational structure of the bank and its employment procedures, conditions, and employee statutes to fit the situation of conversion. 4. Written consent or no objection through an acceptable legal process should be obtained from the existing depositors and clients for transforming their accounts into Islamic mode. 5. The transactions that are concluded before the decision to convert must be ceased or disposed of immediately. 6. Reformatting or designing standard contracts or specimens or exemplars of documents, forms, books, register etc. that comply with Shariah rules and principles. 7. Preparing a special program for preparing personnel and impart them training to deal with the application of Islamic banking practices. 8. Exerting all possible efforts to adapt the ways of dealing with central banks regarding deposits, liquidity needs, or otherwise in a way that does not conflict with the rules of Shariah, especially rules that govern Riba transactions. 9. Any dealings with conventional banks must be limited to the magnitude of the need to do so. 10. Revamping the transactions with conventional banks on the basis of riba-free transactions and the application of instruments acceptable by Shariah. 11. Before commencement of business of the converted Islamic bank, the books of accounts and statement of affairs of the conventional bank must be reconstructed as per Shariah principles. The effect of conversion on the interest-based receivables, impermissible earnings, obligation, and their Shariah alternatives. 1. All traces of conventional transactions whereby the bank originated any monetary assets and is liable to pay interest for them must be liquidated prior to date of conversion. This is the rule whether such transaction involve individuals, banks, or central bank. 2. The bank must confine itself to permissible operations for acquiring the necessary funds to operate or to meet its liabilities. 3. If the capital of the bank has increased due to non-permissible transactions or the accumulation of reserves based on non-permissible transactions, then its treatment must be in accordance with the treatment of non-permissible receivables or other non-permissible assets in the possession of the bank. 4. All interest-based investment instruments must cease to be used and must be replaced by permissible investment instruments prior to date of conversion. 5. All interest-based loans that the bank has made prior to date of conversion must be terminated or converted to Shariah-based transaction. 6. All liabilities in the form of obligation to provide non-permissible service must be terminated by refunding the consideration, even if it has to pay compensation for non-fulfillment of such obligations. Starting from the financial period in which the bank decides to convert, the following must be done. 1. If a conventional bank is acquired with the intention to convert it to an Islamic bank, the new owners are not obliged to dispose of interest and impermissible earnings that have been earned before such acquisition. 2. If a conventional bank is converted by its existing shareholders, then the process of disposing of interest and impermissible earnings should be considered as commencing at the beginning of the financial period in which the conversion starts to take effect. However, for any impermissible earnings that have been distributed prior to conversion, it is necessary, on ethical grounds, for the shareholders and depositors to whom these earnings have been distributed to dispose them of personally. 3. Revenues not yet received that are of doubtful permissibility are not subject to compulsory disposal, whether they were earned before or during the financial period in which the bank decides to convert. The same rule applies to revenues of doubtful permissibility that have been already received because of a belief that they are permissible on the basis of a. an interpretation of a person who is qualified to perform ijtihad on issues that are subject to personal juristic interpretation, b. juristic position of an authoritative school of Shariah, or c. the opinion of some eminent and knowledgeable scholars. 4. If the bank has rights to prohibited non-monetary assets, it may receive them with the intent to destroy them. If the bank is entitled to receive consideration for supplying non-permissible assets or services, the bank may receive the consideration with the intent to donate it to charity. The same rule applies to any income that has been acquired from non-permissible assets during the period in which the bank decides to convert. All impermissible and doubtful earnings must be spent for charity. 5. If the bank is converted and it has, among its tangible assets, impermissible commodities, the bank is obliged to destroy them. If the bank has sold some of these commodities and is yet to receive the price thereof, the price must be received and be spent for charity. 6. If the liabilities are in the form of payment of interest, the bank should employ all lawful means to avoid paying such interest. This rule does not apply to the principal amounts of debts or loans. 7. If the liabilities are in the form of obligations to provide non-permissible services, then the bank is obliged to make every effort to terminate such liabilities, by refunding the consideration, even if it has to pay compensation for non-fulfillment of such obligations. External conversion through acquisition of the bank by parties interested in converting it. If the purchaser is capable of negotiating a deal that could exclude all non-permissible receivables, e.g. interest and non-permissible assets, from the acquisition deal in a way that will make the seller solely liable for non-permissible liabilities, then the Shariah requires the purchaser to do so. However, if the acquisition cannot be concluded unless all assets of the bank including the non-permissible assets and receivables are acquired, then there is no objection to the acquisition on this basis on condition that the purchaser acts as quickly as possible to dispose of non-permissible liabilities, even if the purchaser has to suggest to the creditors of the bank an earlier repayment for a discount. The zakah obligation. When the conversion is initiated by outsiders who acquired the conventional bank for the purpose of converting it, then they are not obliged to make zakah payment for the past financial periods because the zakah for previous periods is the liability of the previous owners. The zakah liability will start to exist for the new owners from the date of the decision to convert. However, if the decision to convert was made by the shareholders and the zakah was not paid for the previous financial periods, the shareholders are obliged to pay zakah for these periods. They must take into account that they are obliged to pay zakah even if the revenues and the money earned are impermissible, because the shareholders are obliged in the first place to dispose of all accrued interest and impermissible earnings, so, the payment of zakah is part of the obligation to dispose of impermissible earnings and interest.